taxation of railroad and other corporations. These corporations are owned by shareholders, the corporation representing the person doing the business of a common carrier, carrying passengers and freight. Their property consists of depots, railroad machinery, tools, and all other appurtenances necessary to the full equipment of the road. And upon the aggregate value of this property, and the cash on hand, the corporation should pay taxes. Government, after a great number of years of unsuccessful attempts to doubly tax corporations, first upon their property, and then upon the shareholders in this property, have come to the wise conclusion of taxing only one of these, and that through their corporate franchise. The commissioners, in their report, page 123, give us an illustration of the difficulties experienced in assessing corporation shares and deposits. In 1861, the amount of stocks in corporations and deposits in savings banks was $232, 156, 227.00 amount taxed. $80,263,840.00 balance untaxed. $151,892,387.00. The whole taxable property of the state for that year was $861,547,583, thus showing a loss to the state of taxable property amounting to more than 1/6 of the whole valuation of the state. But was this a loss? The commissioners fail to inform us how much of this property upon which these securities had a lien was taxed, a very essential item in determining the actual loss. The loss to government, we apprehend, was very little, but the loss to individuals, upon whose property these securities had a lien, was no doubt enormous. And had the law of the debtors' lien been in force, not a cent could have been lost, and it would have been returned to those to whom it rightly belonged. This loss, say the commissioners, was occasioned through the inability of the local assessors to assess resident and non-resident shareholders. But was this property for the purpose of taxation? We have before remarked that these evidences of credits were not property for the purpose of government taxation. These shares and stocks of all kinds merely show the holder's interest in the tangible property named in the security. Therefore, the commissioners could not rightly call the non-taxation of these securities a loss. But could the assessors have assessed these securities, and then assessed the corporation upon which these securities had a lien, this would have been clearly double taxation. The same principle is involved in taxing a mortgaged estate to the owner, and then taxing the mortgage. Only this difference: when you tax a corporate body for their property, and then tax the shareholder for his share in the same property, he represents both the mortgager and mortgagee. Or if government would tax a person for his real estate, and go to the register of deeds and tax the deed of the same property, government would do the same act as it would in taxing the corporation, and then taxing the share. If the local assessors taxed all the real and personal property in possession of the corporation, and then undertook to assess the shareholders for their shares, the shareholders did right in concealing their shares. Government had no right to tax them. We are of those who believe a direct tax should be levied upon all tangible property, and not of those who believe that it is necessary to resort to a dozen different ways of taxing the same property. A franchise or excise tax should never be resorted to, when a direct tax can reach all the property there is to be taxed. Taxing a corporation doing business in this state, organized under the laws of another state, should be in accordance with the privileges granted our own corporations. Nothing for reprisal, but everything for the comity of states, is what we should offer, and what we should expect to receive. We are unable to see how a franchise tax can be made equitable, unless for some special privilege. There ought to be no difficulty in taxing all property without resorting to this tax. The commissioners, in their report, page 125, give us a general plan of the corporation tax, and the principle upon which it is based, which we take the liberty to insert, with our comments. General Plan of Corporation Tax. The scheme may be outlined as follows. It is based upon the right of the state to tax the franchise or right of existence of the corporation, and by it neither its property nor shares, as such, are taxed. But the real estate and machinery of all corporations, being in the nature of fixed property, are assessable by local authorities in the same manner and for the same purposes as other real estate. The only exception to this rule being, that railroads are by law exempt upon a belt of land 5 rods wide, with all the structures within this limit. It will, however, be seen that this exemption, so far as the interests of the shareholders are concerned, is nominal only. Its effect is to transfer to the Treasury of the Commonwealth and to the treasuries of the cities and towns where the shareholders reside, a portion of the tax upon this property, which would otherwise remain with the municipalities through which the tracks of the railways are laid. The treasurers of all Massachusetts corporations having a capital stock are required to make, under oath, a ring return to the tax commissioners of the state, as of the first day of May, within the first 10 days of that month, of all the stockholders, with their legal residence, and of the par and market value of the shares of the corporations. The assessors of all the cities and towns where any of the real estate or machinery of these corporations is located, are required to report the value of such property in detail to the tax commissioner. All assessors being required to return the total valuation of their municipality and the amount of money to be raised by them for state, county, and town taxes, the average rate of taxation is easily obtained. The tax at the average rate in the Commonwealth is assessed upon the valuation of the franchise, ascertained by taking the sum total of all its shares at the market rate on the first day of May, and deducting the value of the real estate and machinery, if any is owned, locally assessed. The treasurer of the corporation is required to pay the full amount of this franchise tax direct to the Treasury of the Commonwealth, and a tax equal in amount upon every share, assessed at an equitable rate, without the possibility of evasion, has been collected. It only remains to distribute that portion of the tax which the state does not retain to the cities and towns entitled to it. This is done by crediting the different municipalities with the proportion of the tax represented by the shareholders resident in those places. When the local treasurer appears to pay the proportion of state tax due from his town, he finds waiting for him the full amount of tax due, in respect to this class of property, by his fellow townsmen. When all has been distributed, there still remains in the state treasury a substantial revenue, the tax upon the stock of non-residents, for the needs of the Commonwealth. This law has proved quite efficient, and there seems to be no trouble in assessing the full value of all corporate property under favorable circumstances. All corporate property should be taxed upon the same principle as that of individual property, and as the corporate body represents the person, no better way to tax them can be devised than the present one, with this exception. The aggregate value of the shares should not be taken as the aggregate value of the corporation's property. Supposing the property was mismanaged, and had become involved and in debt, the same as any individual property, or, as the commissioners say, in their comments upon the general corporation tax, supposing the case of 2 railroads having an equal amount of property, the assets of the first being purchased with the capital stock subscribed by its shareholders, that of the other in part by stock subscription, and the largest amount of bonds the property could be made to carry. The aggregate value of the shares in the bonded road would no more represent the value of the road, than the equity in an estate would represent the value of the estate, and there would be quite as much propriety of taxing the equity in an estate that was mortgaged as the true value of the estate, as there would be in taxing the aggregate value of the shares in a bonded road as the value of the road. Then, again, why exempt a railroad bed? These corporations have, under certain restrictions, the lawful right to take from the owners a strip of land 5 rods wide for a railroad bed, this, with the fixed property put upon it, which usually averages about $17,000 per mile, is by law exempt. The right and equity of this exemption is not apparent from any knowledge we have of this class of property. Analyze the facts, and we no doubt will find that a large amount of influence was the real cause of the exemption. When a road pays a fair interest upon the investment, it shows conclusively that the people contribute their share to its support. Even if a road was not a paying road, we see no reason for exempting it. It would only require a lower valuation in order to make equitable taxation. A railroad should be assessed upon the nearest estimate of its actual value, which could be obtained through the local assessors and the corporation, as now rendered to the commissioners of taxes. the exemption of the railroad bed has the same effect upon the public as the exemption of the property of a savings bank. You exempt the rich and poor roads at the same time. A road may be able to declare a dividend of 15%, and get its exemption the same as a road that paid but 3%. Real estate which pays 3% upon its cost may possibly be rated at a lower valuation, but if the estate remains idle, and could, if rented, pay a fair interest, it would get no abatement on this account. Therefore, why should the real estate of a road be exempt? Capitalists placing their money in these roads would claim an exemption upon the ground that it was, in reality, a public highway, and that it saves the public from the necessity of keeping in repair a public highway, and that they, as capitalists, should be allowed something for these betterments. These reasoners forget that every passenger passing over their road pays them for all of these betterments, and a fair interest upon their investments. It may be that passengers do not pay quite as much per mile traveled now as they would if the road was not exempted, but how does this benefit the taxpayer who rides over the road once a year? Local exemption will not equitably diffuse itself over the whole state, or over the country. Exemption, we believe, should be for the poor and our local public schools, and such charitable institutions as can claim to be truly charitable. But for railroads, the valuation of the assessors can much more equitably regulate the exemption of these roads, or, rather, place upon them a just tax. The commissioners claim that the present law, as now enforced, practically does away with this exemption, and, taxed as a franchise tax, it probably does. Government does very wrong in granting privileges to corporations which they cannot afterward control, thus being enabled to regulate the rights of each, the citizen and corporation. Sufficient control should be retained to secure the public against oppression, fraud, loss, or danger. The commissioners tell us that, in 1861, shares in the Hamilton Manufacturing Company were rated at $1,000 each in Belmont and Carlisle, and at $83 in Pepperell, shares in the Appleton Company at $900 in Medford, and $43 in Brookline. In the Lawrence Manufacturing Company, at $800 in Groton, and $75.45 in Quincy, and in like manner through the state, and to the end of the list. The Secretary of the Commonwealth declared this inequality of taxation to be a very serious affair. So it would be if the shares only were taxed, but if the property was taxed where it is located, we see no loss of revenue from this class of property. On the contrary, those shares, taxed at their full value, was clearly double taxation. And likely the low valuation put upon these shares by the local assessors, or some of them, those of Pepperell, Brookline, and Quincy, were so rated from the fact that they considered the assessment of them double taxation, and placed the rate to cover any loss of personal property at the place where the property of these manufacturing companies were located. The present corporation tax law has done away with most of the inequality of taxing this class of property. This law, as now enforced, is especially adapted to railroads and telegraph companies. Owing to the location of their property, passing from one town to another, it is necessary to tax them in one place to their corporate agents, and these taxes, so collected, distributed where they belong, through the state's Commissioner of Taxes. Therefore, if we tax these corporations for all the property they have in their possession, through the means best adapted for that purpose, coupled with the debtors' lien, we shall have accomplished all we should desire, and at the same time an equitable taxation.